So, welcome to another episode of Legal for Tech, the podcast. Guys, you do recognize my voice here. It's always Rosie, and as I've said many times, this is just a group of students and young professionals who are very interested in anything that has to do with technology and, yes, it's regulation. So, today I'm joined by my boss, non-boss, Giacomo. Hi, Giacomo. It's great to see you.
Well, great to see you too.
Incredibly, we're calling from the same country, but we're calling someone that's not in our country right now. Hello, Robert Bateman, calling us from, I guess, the UK.
That's right. Hello, Rosalia and Giacomo. Nice to be here.
It's a huge pleasure to finally meet you. We've had some issues in getting this interview done, but I'm super excited because meanwhile, a lot of things have happened, and so we can ask even more questions. Are you not so excited, Robert?
Very much so. Yeah, there's always plenty happening and lots going on in the UK as well. So yeah, ask away.
Yeah, perfect. So a year after the beginning of your new government with Keir Starmer, we are here talking to Senior Partner at Privacy Partnership, Robert Bateman. And I would like to know, Robert, what led you to this path? Why are you so interested in data privacy, data protection? Why are you here today? And yes, what's the future got in hold for you?
So why data protection? Well, I started out being interested in this subject while studying law, which is probably the case for many people in the fields. But one thing that I took a particular interest in was a UK law, part of the Data Protection Act here, about what was called the immigration exemption. This was quite a nasty bit of UK privacy and data protection law, and I wrote a research project on that during my law degree, arguing that it was invalid under human rights law. That actually proved to be the case in the end, but it was a different argument from the one I used, so I can't take any credit. So that was around 2017, and since then, well, I started out writing about data protection as a journalist, got to know lots of interesting people within the sector. I've interviewed people like Max Schrems and Johnny Ryan from the Irish Council of Civil Liberties, and managing data protection related events for a while, then got into training and consultancy. So I train on all matters of data protection law and also increasingly AI related stuff, as companies are so determined to shove this technology into every aspect of their operations. And I am a consultant and senior partner at Privacy Partnership, which is a kind of boutique consultancy, and we offer advice on all sorts of data protection and AI related stuff. So yes, I joined the field around the same time as lots of other people during the sort of GDPR era, but have really taken to it and do a lot of kind of speaking and writing on the topic still.
What can I say? Amazing career. But let's talk about a relatively recent legislation action, the UK Data Bill. What are the main reforms introduced by the bill and why, if so, were they necessary?
So this is the UK's Data Use and Access Act, and I keep calling it a bill, so please excuse me if I do so. It's now, of course, law. King Charles gave his royal assent to this legislation last month. It would have been quite surprising if he hadn't, because that hasn't occurred for several hundred years. But it is quite a complicated piece of legislation, actually. It has, I think, 8 parts. 5 and 6 are relevant to data protection, and they reform the UK GDPR, which is still, for all intents and purposes, identical to how it was before we left the EU. And also the Data Protection Act 2018, so that's the UK's kind of legislation supporting the GDPR, and the Privacy and Electronic Communications Regulations 2003, which is the UK's implementation of the e-privacy directive, so cookies, electronic direct marketing, those sorts of things. It's complicated in that it only amends these existing laws for our purposes. There's a lot of other stuff in there about smart data schemes and digital verification, but I'm only really concerned with the data protection and privacy bits for now. And it puts in a lot of fiddly, very specific changes to wording in the UK GDPR and PECA, as it's called, the e-privacy law. It is very important and very significant that the UK has done this, but it's not all that ambitious. The proposals, and we'll probably talk about this shortly, have been scaled down quite a lot over the last few years from when they were first introduced by Boris Johnson's government. And we've ended up with quite a modest piece of legislation that does change things and is very exciting for us consultants and commentators and data protection people, but is quite hard to get other people excited about. So I did training on this law, and the training sessions can be very good, lots of people contributing, lots of discussion about it. But at the end of the session, often people say, well, I'm glad I know about this, but I don't think it really changes very much for my business. That said, I don't want to downplay it. There are some really important bits around automated decision making, for example. Cookie rules are changing in the UK, and there is a kind of new fining regime for the e-privacy directive, which is quite important. And also the regulator is being restructured quite significantly. So the changes are quite specific. They are important, but they are not kind of earth-shattering. They're not as ambitious as previous iterations of this law have been.
Do these changes target primarily, for example, big tech companies of the kind of obligations that are in the DSA, for example, or would you say they're more like widely spread and more even in terms of which kind of controllers, which kind of sites have to abide to them?
It's a good question, and no, it's not really it doesn't really target big tech. We do have other laws that will have big implications for big tech companies, like the Online Safety Act, which is not really, I mean, it's vaguely similar to the DSA in some ways. It has content moderation obligations, and it goes further than the DSA in some ways, actually. The Data Use and Access Act is more of a generally applicable law. I think it will mostly actually impact companies that primarily operate in the UK, because most of the new rules are they offer less protection and a lower compliance hurdle than the EU's GDPR. So if you're operating in both jurisdictions, then you could probably you don't necessarily have to change much, because you'll be meeting both laws. It's not like it's kind of stricter in the UK now. There are some areas where there are some small obligations that go above the letter of the GDPR, the EU version, that is. For example, there's stuff about complaints handling, where organizations have to have a complaints policy now for data protection complaints. They have to respond within 30 days. And they might have to report the number of complaints they get to the ICO as well, the UK's Data Protection Authority. But most of them are generally applicable. They're not targeting big tech with this law, I think it's fair to say.
We did mention the word GDPR, and you finally you gave me a great assist for asking you the next question, which is about the recent report that the European Parliament published about the UK's proposed strategy for revisiting some innovation trampling obligations in the said GDPR. So I would like to know, what are your thoughts on this British attempt, and whether it is worth pursuing, because we know that the GDPR is very important in protecting the rights of users and data subjects online. So do you think it's worth it for the price of innovation?
Well, I read this report, and it seems that the focus is on the various failed attempts by the UK to reform its data protection and privacy framework. So, as I mentioned, this first came in under the Johnson government, and the earliest iteration of these reforms were in a 2021 report called the Tiger Report as an acronym. I can't remember. Task Force for Innovation and Growth. And that went very hard on proposals to amend the GDPR, like scrapping the automated decision-making rules entirely, for example. And it also was pretty wrong about what the GDPR actually is, and it made some of the common mistakes. You need consent for everything, people own their data, those sorts of fallacies. So that was not a great start for these reforms. And then we had a consultation, which was much more legally correct, but also made some quite bold proposals for reform. Then we had the first version of the bill. Boris Johnson said he wanted to get rid of cookie banners entirely, and that wasn't quite iterated in the legislation, but it was more bold than what we ended up with. And gradually, some of these more controversial aspects ended up being stripped out. I think that the government is quite worried about maintaining its EU adequacy status. So proposals, for example, to scrap data protection officers were in the first and second version of this bill. They would have been replaced by senior responsible individuals, so a management level person responsible for data protection. We also had bolder ideas about reforming records of processing activities, data protection impact assessments. They didn't make it into the final bill. So I think this European Parliament report, they're trying to say, well, what can we learn from the UK's failed attempts at going quite hard on data protection reform? And the answer is not much, I think, because the reason we didn't go further was because we're worried about the EU's adequacy decision in relation to the UK. Now, the EU doesn't have to worry about that because it makes its own rules. They can pretty much do as they wish. They don't have to worry about a larger neighbour that might restrict trade somehow. They also have the highest standards, and it wouldn't affect trade with the US, its biggest trading partner, I think, because their standards are much lower. So we don't really know what impact these reforms will have yet. The EU would have to worry a bit more about human rights law, I think, than the UK probably does. But it's not quite a fair comparison because the EU doesn't have to worry about its own adequacy decision, which is, I think, why the UK decided to strip these reforms back a bit.
Talking about my lovely GDPR and how to make things easier or worse, may we ask your opinion on the topic of proposed simplification to Article 30 of the GDPR as put forward by the Commission?
So the Commission has proposed a few things in relation to simplifying the GDPR, and I think lots of people were quite disappointed by what they came up with. Basically, just to summarize, they want to allow organizations with up to 750 employees a bit more flexibility with regard to record keeping, and they want regulators and other bodies to consider the needs of medium-sized companies when setting certifications and codes of conduct. Now, this, I don't think, will make much difference to anybody, to be honest. There's already a limited exception for companies with less than 250 employees when it comes to record keeping. I've worked with smaller companies, and it doesn't really, I don't think I've ever pushed anyone to take advantage of that exception, because you have to keep these records in other places in a way, and your privacy notice has to have this information. It's a good idea generally to keep these records. I think if a company really doesn't benefit from doing it, then I would actually approve of more flexibility legally, saying that they don't have to do this, because it's kind of an internal record keeping process. I have met people who say this is a complete waste of our time. We don't see any benefit from keeping a ROPA, as it's called, records of processing activities. So I don't think that those reforms will make much difference. Maybe the Commission is being a bit conservative because it's worried about what the courts would say, the Court of Justice, about reforms that remove people's human rights, essentially. But, I don't think many companies will see much benefit from the proposed reforms.
Would you say that this is more like of a statement of the Commission wanting to signal companies like Europe wants innovation. We don't want to trample your access to Europe. We don't want to block you, and that's our step forward. It's just a statement. It's a way of communicating that they want them to come.
Yes, I think that is what it constitutes. They're doing something. It's not nothing. I think anyone who understands what's being proposed and reads it and has worked in the sector too, will realize that this is not going very far at all. But yes, I think that's right. I think it is more of a statement from the Commission. Whether it's a good statement or an effective one is another question.
There is a question that is particularly relevant also for me. The topic is the way the GDPR operates is related to training of AI models using personal data. Where do you stand when it comes to this increasingly complex question?
So it is a very difficult question. And for a long time, I was saying, well, the GDPR is actually quite well set up to deal with AI. The automated decision-making rules have been there in some form since the mid-90s under the previous legislation. And the principles of data processing apply to AI systems as much as they do to any other systems that process personal data. The problem is that I do think there are real tensions between AI and generative AI and large language models in particular, that with the GDPR, and particularly with regards to rights and freedoms. So the data subject rights, how to exercise your right to erasure against AI models that have been trained on your personal data or to correct it. There aren't easy answers here, and I think we've seen some pretty flexible interpretations of the law, even coming from the European Data Protection Board in some cases, which has surprised me. The main problem, though, is that it's quite ambiguous and there's no clear answers for businesses that want to do this stuff. I think this is where certifications and codes of conduct could come in to provide a bit more clarity on what people are allowed to do, whether or not consent is required to process someone's personal data for machine learning purposes, whether, for example, removing someone's data from your training data is sufficient to fulfill their right to erasure, even if you've already trained the model on it. A strict and almost straightforward reading of the GDPR would suggest that those things are not satisfactory in this context. But we are seeing different interpretations from different data protection authorities, which I think is not helpful. We don't have a lot of court of justice rulings that deal directly with this stuff. We've got some stuff from the European Data Protection Board, but I must say I don't find it particularly enlightening. I think it leaves a lot of unanswered questions, which is understandable because the answers are not obvious for a lot of these questions. Ethically speaking, I mean, I personally am not that bothered about my personal data being used in this way, and I'm someone that does care about this stuff, but other people are different. I think the Noib case against Meta made some very good points about human rights in the AI context. So they said that, for example, people should be allowed to object to the use of their data in this way, but that objection should be valid retrospectively. So you should be able to object to your data having been used in this way and being processed by the model on an ongoing basis, which is basically impossible without doing another huge training run. I think that until we get some clarity on how the GDPR applies, probably from the Court of Justice, to be honest, which is not best known for its very clear judgments in any case, then we're going to see companies continue to just go ahead and do stuff, whether or not it's technically legal, which is not a great situation to be in.
At this point, there's a question that's kind of burning in all of our minds. It's about consent, which, said like that, is already quite interesting. So we know that some companies like Meta, for example, have given, in some countries especially, their users the possibility of opting out from giving consent to the use of their data for the purpose of AI training. So, for example, in Germany or even in Italy, you had until the end of May 2025 to opt out and state that you didn't want your data to be used as part of the training for Llama, so Meta's AI. Do you think that that's a feasible option? Do you think that users are well informed enough to give that level of consent? Do you think that the procedure means that people are actually expressing their free consent, or it's just like so difficult to follow that then people are just like not going to be bothered? And also, since you are an expert also when it comes to cookie policy, we know that cookies really do work on giving consent or not. And that's quite of a, I would say, a gray zone, whether that's free consent or it's just, please get off my phone and let me go on this website. So do you think that we should learn something from how cookie policies have been updated and upgraded throughout time in terms of how consent is given when it comes also to its being given in relation to training with personal data of AI and other similar technologies?
Yeah, great question. So I'll break them down a bit. So firstly, when it comes to what Meta's doing, I sometimes, I don't want to say sympathize, but sometimes I am a little bit less harsh towards Meta than some of my colleagues. In this case, I'm not crazy about how they've gone about obtaining training data. They aren't even purporting to rely on consent in this case. They are offering an opt-out and relying on legitimate interests. I don't think that's necessarily illegal. I think in the case of Meta, more time and a better explanation would have been preferable. Ultimately, I think consent would have been better for this particular processing, but then they would have got less data. So that's why they don't want to do it that way, I assume. In this case, we see people could be, they could be using photos from a long time ago, decades ago, that people are uploaded to Facebook. And we know that AI systems, whether or not they contain personal data, AI models, is a debate that I won't take a position on, but they do produce it, and they can just reproduce or parrot their training data. So people might not expect their stuff to turn up in this context, and I think that would be quite disturbing for some people if it did. So I'm not keen really on how Meta has handled this specifically. As for whether you can consent to this type of processing, given how complicated it is, I think yes, in theory you can. I'm a little bit more liberal than some privacy advocates in this regard. I think people should be allowed to choose this sort of thing. I don't know whether it's possible to become fully informed about it to the extent, I think it's possible to be informed to meet the GDPR's threshold of being informed or giving informed consent. But that's not to say that people will be given a free choice in GDPR terms. Like you say, as a comparison to cookie banners, people usually just agree to those to get rid of them. I think it would be a problem if that same model was emerging with regards to training with personal data via AI models. I wouldn't want people to accept it without at least having a decent understanding of the implications. Now, what those implications are, it depends on the context. So when it comes to Llama, perhaps reproducing parts of a post I made in 2010, and I'm pretty sure I made some embarrassing posts over the years, so I'm not crazy about that idea. That consenting to that, I think, carries less risk than consenting to certain other AI-related activities. So I am a bit worried about scope creep here, where, you know, if we think down the line, what are people going to be using AI systems for? Could consent to having our data ingested by those have much more serious implications? Legitimate interest is emerging as a basis for some training of AI models. There are some authorities across Europe who have basically said, yes, it's okay within certain parameters. I think that is probably the right approach for some types of AI, some models, and not others. So the world of data protection and AI regulation is not getting any simpler. These new questions are going to cost a lot of legal hours in people thinking this stuff through, I think, and a lot of pontificating about the various provisions of various laws. The AI regulation, of course, is impressive in some respects, but very, very problematic in others, and very complicated in some areas. I appreciate a bit of a non-answer, but I don't think it's always going to be reasonable to require consent to everything. And there are contexts in which I think we could use AI systems without consent within proper boundaries, you know, in suitable contexts. Where we are asking for consent, I really think people need a bit of hand-holding to help understand what the implications of that are. And of course, there are some cases where transparency is not enough. You know, there are some practices that should be prohibited outright. The AI Act has done a bit of this. I think some things are implicitly prohibited by the GDPR, but transparency and consent is not an excuse for doing things that are legally or ethically wrong, I think.
I see your point, and yes, sometimes it can be a really non-answer, but like really, with the level of knowledge we have now, I think it's really difficult to give a defined kind of I believe this type of answer when it's not really clear what's happening really to this data. I mean, a couple of weeks ago, an article slightly sensational published by a British newspaper, The Guardian, was implying that apparently one contact that had been saved into someone else's phone had been kind of conjured up by Meta AI on WhatsApp, and then the content was actually on the website, so it wasn't really coming from anyone's phone. So it's that kind of like gray area where you really don't know whether your data is coming from the phone, from your conversations, from your social media posts, or it's simply coming from the internet. You completely forgot that it was even there. So I guess that's the bigger issue, is understanding what's happening with the data more than defining which areas and which types of data you can give consent to, because as you said, many of these are already regulated under the GDPR.
Yeah, and you know, these adversarial attacks against AI models or using AI systems are very real and very worrying. We've seen it happen, and I don't know about that Guardian case, but New York Times had an interesting piece about ChatGPT being, well, it's hard not to anthropomorphize it, being tricked into handing out people's email addresses, you know, reproducing part of its training data. I think in theory, the law prohibits some, well, it's hard to say, isn't it? Because the scope of the training process and the scraping means that it will inevitably end up with personal data in the AI training set. I have seen arguments that this should not constitute personal data processing at all. I don't buy that. I think that we need to put guardrails on that aspect, and trying to improve people's approaches to training and scraping and gathering data for training purposes is probably better than prohibiting it outright. There might be some role for anonymization technologies at that stage. I'm not sure of the state of the art at present. I know that the term anonymization has been abused a lot throughout the years, so I wouldn't want people to, point to that as a kind of excuse. It happens in, many quite worrying contexts, healthcare and so on, reusing personal data. This is something actually under the UK's law that I think they are trying to make it a bit easier to reuse personal data in the health sphere for research purposes for different contexts. Probably it doesn't mention AI training, but they probably had that in mind. Now, having said that, I'm not a kind of purist on this stuff. I think particularly in the healthcare sphere, maybe not so much with large language models, but there are some fantastic AI use cases. The kind of old school AI in particular has been making improvements in some specific healthcare aspects. And I do think large language models are pretty useful. They do have their uses. I'm very skeptical about how useful they are generally, but I've found them to be useful in very specific contexts. I don't use them to write per se, but they do have their uses. I wouldn't want to completely prohibit them. So I think we have to think about whether the regulations we place on AI developers would have the effect of prohibiting these systems altogether. If we want to do that, I think it would be better to do it outright, rather than just cutting off the various ways that these systems are built and trained. We should probably have a more democratic conversation about whether we want this technology in society or not, because shutting off all avenues to developing it would have that effect almost inadvertently.
To have that democratic conversation, we think that it's particularly important that our listeners and anyone that's actually listening to this podcast right now will be given all the possible instruments to understand what type of conversation this should be. It must be an informed conversation. And in that light, we're asking you our last question, but also a suggestion as a friend and as someone who understands so much better than the average person what we're talking about in this case. Do you have any suggestions of books, podcasts, TV series, anything that comes up to your mind that may help listeners making a more democratic decision in the sense of democracy?
Well, look, I read a lot of stuff. I want to recommend people really on social networks to follow rather than publications, apart from, of course, my own newsletters and privacy partnerships newsletters, which I do recommend. I put out videos and stuff as well. But besides me, there are other people that I found really valuable to follow. There are too many to mention, really. But on the AI Act front, there's a lawyer called Alexander Tulkanov, who is very, very good on understanding the AI Act. Tia Mustach as well, who works alongside Peter Hens, I think, who has been on this show. They are both very good to follow when it comes to the AI Act specifically and AI regulation. Peter is particularly cynical about this stuff and is a litigator. So if any of my statements have been a bit too wishy-washy and ambiguous for your liking, then I recommend following him because he does not mince words. Ria Alexander Waller is really good as a way to keep up to date with developments at EU level, particularly in data protection. And she has a subscription as well that I can recommend. In the UK here, particularly spring to mind John Baines, a lawyer who really gets into a lot of detail about UK litigation and legislation and regulation, and also Tash Whitaker, who's very good with kind of broader data protection issues. in the UK. So, I mean, there's thousands of people that I haven't mentioned there. Oh, Kerry Leaning as well is very good on the kind of ethical and kind of broader stepping back and looking at how AI has been developing and the regulatory side too. So there's 100 people that I've missed off that list, so I apologize if you think you should have been on it, and you're probably right, but those are the first people that sprung to mind when you asked.
Robert, what can I say? You're great at giving me potential kind of assets to make a great plug, because we have talked indeed to Alexander Tulkianov, we have talked to Peter Henze, Thea Mustache, and of course Kerry Laning, who is a great friend of ours. So guys, this is a great shout out. Go listen to all of these podcasts, and we also have talked to Ria, Alexander Vale. So everyone, please do listen to these podcasts, and do follow the page, of course, Legal for Tech. You forgot to mention it, but I know you do follow us. So
that was top of my list actually, but I neglected to read it out, so apologies.
Absolutely. No, we do thank you for your support. We do have greatly enjoyed this interview, and thank you for the great tips. So I shall say thank you, Robert Bateman, for this incredible interview. It was a great pleasure to see you.
Thanks so much. Pleasure to be here.
And thank you, Giacomo, for joining me as well.
Thank you, Rosie. Thank you, Robert.
This was all for Legal for Tech, the podcast.